think that most of you, as typical attorneys, have had cases that you didn't get paid on, okay? You did all the work, and then at the end of the game, the client refused to pay you because they couldn't pay you because they didn't want to pay you.
Never heard of such a thing.
Never heard of that, did you, Mike?
Yeah.
Well, then there are those of us who have started in practice, just like I started in practice without any experience, and you figure out how are you going to get paid. You say, well, I've got to have a retainer agreement. So you go to the form books, and you get out the retainer agreement, copy it, and then you go through each clause to make sure it's compliant with RPC 1.5. Is that correct? Well, I think that most people probably just use the form book. And think about how do we make our decisions about our ethical decisions. Well, do we call the hotline? Do we hire an ethics attorney to give us advice? Maybe. Do we talk to a senior partner in our firm? Maybe. Or if you aren't with a firm, maybe you just give a friend a call and say, what do you think? And the friend may have never been introduced to the RPCs. So what ends up happening is that we think we know what we're doing, we think it's right, and most of the time it is, but once in a while, attorneys unwittingly run afoul of the ethics rules. So we're going to talk about today how to formulate your retainer agreement so that it complies with the ethics rules, so that it protects you, and how to set up the fee arrangement so that you can get paid. Now, I've provided you, we sent you an outline, we sent you then our PowerPoint. Most of the information that I'm going to talk to you about is in this material. I don't give copies of cases because I find most people want to just say, hey, I can get it on the internet. But any copies of cases that you want, let me know. I'm more than happy. I've got them all stored on my computer. I'll send them right out to you, no problem at all. Now, also, any of the fee agreement clauses that I've put in here, you'll notice that none of this is copyrighted. So if you need any of the information to use for any briefs, memos, just go ahead and copy of it, and it's on tape, and I'm giving you my permission to do that. Now, I first of all want to acknowledge Joe Myers for being a sponsor today. He's going to come by later on and just say hi to you before you all leave. And Joe is financial planner. He's my personal financial planner. He's got me through those bad times, so I can certainly attest to him. And I also want to thank Gary Borger and the firm of Borger Jones Matez for hosting this event in their beautiful offices today. Gary's going to be joining us in just a few moments. Now, the next slide is really going to sum up what I think about legal fees. Well, actually, it's going to be the next one after this. And that is a lawyer unpaid is justice denied. Because if you're working so hard, like I know you all do, don't you just feel ripped off when the end of the day comes and you don't get your money? And the fact of the matter is, lawyers get a bad rap. A lawyer is a gentleman that rescues your estate from your enemies and then keeps it for himself. It's the trade of lawyers who question everything, yield nothing, and talk by the hour. That's Thomas Jefferson. But the fact of the matter is, I fully believe that most attorneys are very sincere about their work, that they are more than competent and give awesome service. But what we got to do is portray ourselves to our clients in a way that shows them that. Now, as a lawyer, you're running a business. It used to be frowned upon looking at this law as a business. But the fact of the matter is, I think you have an obligation to run your practice efficiently. You have an obligation to make a profit. Because if you don't, then how are you going to be in practice to serve these people that you spent so many years studying for, and at this point in your careers, that you have spent so much time getting the experience. So you deserve to get paid, and don't let anybody make you feel bad about it. Now, we're really, the legal fees are really regulated. It's not just market forces. You know, like, oh, you know, what do you pay? You're a lawyer. And by the way, what do you say to someone when they say, well, the guy down the street charges a lot less than you do? My response was, I can't comment on the other attorney's business practices. All I can comment on is the cutting-edge service that my firm prides itself on giving. So if you allow people to cut your fees, then you're really allowing them to devalue your service, which certainly shouldn't happen. Of course, we've got the rules of professional conduct, the RPCs. And by the way, in today's presentation, the RPCs that we talk about will be New Jersey's rules of professional conduct. We have model rules, and certainly they've been adopted in various renditions in various states. Now, of course, then court rules, case laws, and then ethics opinions, which we are going to go through a few of the ethics opinions today. Now, you know, most of us will agree, and most will agree, that legal services have value. But then the question always becomes, what is the value? And how do we determine it? I think in making that determination, we have to first think about what is it that we're selling. Okay, are we really selling time? Or is what we are really selling is expertise, skill, innovation, service? And how do you value that? I'm going to come up with a few suggestions, and I'm going to be interested in hearing your views on how you charge and what some options are other than the hourly rate. Or of course, typically we know it's been hourly and contingent. Now, then the other issue, how much? Who's going to pay? Okay, it's got to be somebody. And it's either going to be your client, friend, a third party. Best of all worlds is an adversary. We love it when the adversary pays, or sometimes in a fee-shifting situations, or sometimes even the government pays. Now, when do you get paid? We always hope as soon as possible. Okay, my attitude is upfront, and upfront. Because Jay Foonberg, who is one of the granddaddies of the starting your solo practice, he came up with a bell curve, a curve of the decreasing appreciation. So a client comes in to see you. They've been charged with a crime. Like, oh my God, help me, help me, help me, you're the best. I can't do. Then as time goes on, they're like, you know, I could do this. Then when it comes time to pay you, why should I pay you? I could have done the whole thing myself. It was so easy. And that is why it is so important to create ways to show clients what value that you actually have. You know, sometimes we're going to talk about these cases, not only do lawyers not get paid, but they even have to give money back. And that's an unfortunate situation. Now, first rule of thumb, all retainer agreements in writing. Now, you notice it doesn't say some. It's all. Under the rules of professional conduct of New Jersey, it states that any fee agreement, retainer agreement with a new client, then you put it in writing. My attitude is, just because someone's an existing client, that doesn't mean that they're not going to get confused about the fee arrangement. Because in fact, maybe you've charged them a certain way for one type of matter. Now you've got another matter that you're going to represent them on, and you need to charge a different way, or there's different types of costs. Get it in writing. Now, the clear writings are going to go a long way to helping clear up any misunderstanding, if there is a misunderstanding between the two of you. You know, the retainer agreements, it's really in the past, it's like, it's for the protection of the client. I look at it from the perspective that it's the attorneys that need to have the protection. So protect yourself and have a written retainer agreement. You know, you never really thought when you went to law school that you were entering into a high-risk profession, but unfortunately that's what the practice of law has become. Now, what happens if you don't get your agreement in writing and the client doesn't want to pay? And it's a big enough fee that it's worth filing a lawsuit over. Okay, which is, you'll see, I'm not in favor of filing collection suits against clients for the reasons that I'm sure has already come to your mind. But what if it's just such a big fee you can't let it go? Well, we all remember from law school the doctrine of quantum meruit. Well, here's what happened in with the Cole-Schatz firm. Cole-Schatz was retained by small companies, and 4 individuals came in and their companies. They were minority shareholders, and there was a derivative suit where a majority was trying to take over. And so the corporation, there was a retainer agreement, but the individuals, the attorney kept saying, like, you got to sign this agreement, kept doing the work. No, don't pay from the company, you got to pay me from your individual. Nonetheless, they paid from the company. All right, the litigation's all said and done. Well, unfortunately, the case was a loser. Law firm wasn't successful. Corporation stiffed the law firm on the fee. And then the individuals said, well, we're not paying because you don't have a valid retainer agreement with us. Well, the court held that, guess what? We're not only going to hold the corporation, got a judgment against this corporation. 1, 2, 3, 4, all you individuals, everybody is jointly and severally liable for this fee.
So they got the fee?
They got the fee. And
I thought you were going to say they didn't.
They got the fee. They got the fee without the agreement, and it was quantum meruit. Haven't heard of that one in a long time. But and here's your 4 elements. They're listed in your papers. And I hope you never have to rely on a quantum meruit argument. But if you do, at least in New Jersey, then you've got a shot of it coming through. Now, the agreement's also got to be in writing, but you also got to explain the agreement to the client. I think if you're having any unusual terms in the retainer, that you might even want to have the client initial the terms, just to make sure, like, hey, they really understand all of this. Now, there was a 2010 New Jersey case, the Alpert Goldberg case, again in your materials. And here's what these folks did. Their retainer agreement, they have a master retainer. Okay, you sign a retainer, but there's a master agreement if you really want to see what we're charging you. Go make reference to that. Well, when the client got the bills, they were really outraged and didn't want to pay. And here's what the master agreement said. It said 12% interest. Wow, in 2010? You know, back in the 80s, okay, 12% interest was pretty par for the course. You got to pay our secretarial overtime if our secretaries work for you. And by the way, if we have to sue you for a fee, then you'll pay our collections costs. And on top of that, if we have to make a motion to withdraw, you're going to pay all withdrawal costs. And the court didn't like this one. And so what the court said was that you've really impermissibly made a shift to the client to have a duty to go in there and look for your master agreement, where, you know, whatever vault that happens to be in, and said, no, this particular agreement does not hold up because you didn't adequately explain it. Now, we've got a number of different types of fees. I mean, you know, how many have used hourly? Yeah, most of us hourly. Flat fee. Flat fee can be pretty good if it's something that you do a lot of, and you can really cost it out as to, you know, so sometimes you win and sometimes you lose. It's like I look at, my practice was mostly flat fee. And there's this principle called Pareto's principle. And basically, in any given situation, it was really applied to economics. Like in where it first came up was Pareto was an Italian mathematician, and he noticed that 20% of the land of the individuals owned 80% of the land. And it's been shown throughout. So in your law practice, you'll also see 20% of the people cause 80% of the aggravation. So it's, of course, you figure
Smaller
out.
percentage.
Yeah, figure out who all those are.
5%.
Right, and those you wish that you had hourly plus success bonus. So then you get your flat fee, contingent, now your hybrid fees. That's where it starts getting a little bit interesting. See, the hourly rate, if you think about it, it really is a reward for the inefficient. Because the more time you take, the more money you make. And here's what I think that some attorneys might do, is they have the hourly rate with the client and say, well, you've already got your forms together, kind of amortize it and say, well, so I gave it to the secretary, it was only 2/10 of an hour, it would have taken an hour, so the hour gets billed. Unless the client is aware of that, that does run afoul of RPC 1.5. So you really need to get it in writing. So what do we do? What do we do about these? We're leveraging ourselves these days. Okay, we leverage ourselves. It used to be just with people. Now we have the wonderful world of technology to leverage ourselves. And so the old hourly rate fee just really doesn't necessarily make sense. So one way is that you might have a hybrid fee where you have a case that's not that great of a case. So as an attorney, you say, well, I don't really want to take it on a contingency. But it might have a shot. And the client says, well, I don't want to put out a big hourly fee. So you come to a compromise. You have a hybrid, a low hourly rate combined with the contingency. Has anybody used those at all? I see some people use them and have been happy with it. Then you have the negative contingency. I know the negative contingency is used in real estate tax appeals or in defense work. So what happens? Let's say the defendant gets sued for $100,000. Well, what you do, you may have a flat fee or a small hourly fee with a built-in success bonus. Now, the way that the success bonus would work is you decide what's a threshold of success. So your client, the defendant, says, all right, if I get out of this for $50,000, that would be that's a winner. So then what you do is you come to an agreement that the contingency is the difference between what your outside liability is and what the defendant actually ends up paying. And I've talked to some people recently that the defendants, they love it. And the attorneys that I've spoken with, that we've been able to, you've got to be able to identify the proper case, and that's always the art in setting fees. That's always the art. Now, then of course you've got the hourly fee with the success bonus. Well, those of you who do matrimonial work down here in South Jersey, you may want to consider a switch up to Fairfield, Connecticut. Because in Fairfield, Connecticut, there's a fellow attorney, Gary Cohen. Well, he's a matrimonial attorney. Well, Gary's practice was $600 an hour. Okay, 600. Everybody pays $600 an hour. And then there is a clause in his retainer agreements that reads like this: in addition to the hourly charges, we may request an additional reasonable charge for matters of extraordinary difficulty or which require special expertise or the giving of special priority treatment. Well, this got this guy into some hot water. Oh, that's so wrong.
That must have been priority treatment.
Oh, we're going to get to that one.
That's special treatment.
Yeah, special treatment. Well, in in the particular case that was the most egregious one, they bundled 3 of the cases. They compiled 3 of them together against this guy. And in the one that was the worst, his client was named Zimmerman. So Zimmerman comes and says, oh my God, my wife filed for divorce out in Nevada. For some reason, they said we don't want jurisdiction to be there. So let's do something. So Cohen comes to the rescue, and they have a meeting, 4-way meeting in Chicago, in a hotel, for 5 days. And at the end of the 5 days, the case settled. But Cohen said, whoa, wait a minute, client, not so quick. Success bonus. I know you've already paid me $150,000. Okay, that's the hourly bill you're up to at this point. But in addition, you're not only going to pay me a success bonus, you're going to pay your ex-wife's attorney, your soon-to-be ex's attorney, a success bonus to the tune of $300,000 each. And we're going to make sure you pay it, because this phone, wire it. And he did. The guy did. But then, you know, he had buyer's remorse later. And the federal court ordered Mr. Cohen to repay $371,000. Now, the ethics committee in the state of Connecticut, they didn't quite have so much trouble with this arrangement. They said, well, it's not a contingent. This is truly a hybrid hourly fee. Now, the master who went around to just say, what's going on in the community here? The other matrimonial attorneys, $1,200 an hour. This is basically what this guy was getting, was $1,200 an hour in many of his cases. Hey, for the risk we go through, you know, cost of our malpractice premium, you know, if we screw up, then we could go bankrupt, so this is reasonable. And in fact, Mr. Cohen was not found to have violated any of the ethics rules. But now we get to the juicy.
But he still had to pay the money back?
He had to pay, because that was a federal court. So that was a case, I'm sure, for disgorgement of fees. But then then an ethics complaint was simultaneously filed.
He taped his client? Is that what you said? On his cell phone?
No, he gave the phone to the client and said, get the money wired to me. Yeah, I may have missed
It did sound like he was wired, yeah.
Yeah, oh, got it. No, yeah, I got it. No, he wasn't wired. He said, wire the money to me. And frankly, I'd rather have $300,000 wired to me than to be wired. So, in any event. And here's another rule of thumb. Don't accept sexual services in exchange for legal services. You may think this is obvious, but it's really an age-old problem. First of all, I know lawyers don't get out much. It's tough to meet people. But, you know, there's speed dating, there's J dates, there's Redstone, so don't depend on your clients. Now, nonetheless, attorneys continue to test this seemingly simple rule. Now, in New Jersey, we did not adopt RPC 1.8J. The ABA proposed rule 1.8J said you can't have sex with your client unless you had a consensual sexual relationship before you started representing him or her. Now, to me, that brings up a set of problems. Why would you represent somebody that you're having sex with? Because what if you lose? Then you're not only not going to get paid, but other parts of your life may suffer as well. Now, in New Jersey, for those attorneys that are found to have had sex with their client and for whatever reason there was a complaint filed against them, here's where New Jersey relies on its 8.4b, and that's misconduct. So even though there's no specific prohibition, you still can be caught under the 8.4b. So let's talk about David Witherspoon, New Jersey attorney. Well, on at least 4 different circumstances, David thought this would be a good way to get paid. So, one of these cases in which a complaint was filed, it wasn't sex with his client he wanted, it was sex with the client's daughter. So I said, look, if your dad owes me $300, come to this hotel with me for 3 hours and we'll forgive the $300 fee. Well, I don't know if she really did it or not. I didn't read that far. But then, in the same case, he made another offer to her. If you will come into my office and dance for me, then we'll knock off $200. So this guy was, it's very unsavory. Well, then...
Very lowly.
Yes. Imagine.
Well, then there were 2 women who came in to inquire about bankruptcy. And he said, look, if you will kiss in front of me, then I'll file the bankruptcy for free. And then furthermore, they needed an amendment later on, or one of them needed an amendment. Said, hey, if you lift up your skirt, I'll do an amendment for free. This is really serious. You know, it's like you can't make this stuff up. You know, I've always threatened to write a book, and you don't need fiction.
How did he get found out?
The clients complained against him. I mean, finally, they just kind of said, hey, I'm going. You know, who knows why people either do it or don't do it and then go and file a complaint. And believe it or not, is that he was not disbarred. There were 2 justices that wanted disbarment. Oh, he said, well, I have a relaxed atmosphere in my office.
Clothes optional.
Well, yes, clothes optional. Now, I'm from Indiana, and I always thought those Indiana boys were well behaved. But William Wallace, who was actually was running for county prosecutor up until June 2010. And when a complaint was filed against him for he had sex with a client, so that in order for him to forgive $550 in legal fees. So I think it was only once. Now, so he, all of his needs were satisfied, let's put it this way. Now, another Indiana lawyer, he stands for the proposition that even if you give the money back, you can't have sex with your client. So what happened with this guy? It was a divorce case. After 2 months, they became intimate. He gave the fee back. He said, no, here, I'll do the divorce for free. But then she reconciled with her husband and a complaint was filed. Now, why was that complaint filed? You know, probably in the throes of confession. You won't believe I had sex with the attorney, and you know, we know how that one came down. So, 30-day suspension for that fellow. So, that's that. Let's get on and talk about what fees are reasonable. You know, this has been, for 500 years, we've been trying to figure out what types of fees are reasonable. Again, look at RPC 1.5a. And this gives the list of things that will be looked at. Now, if you ever have a fee arbitration complaint filed against you, this is a wonderful, go immediately to 1.5a to start looking through the factors if there is an accusation of an unreasonable fee. And so, for example, time and labor required. It's on page 10 of your handout. The novelty and difficulty of the question. Now, we're not talking about the novelty and difficulty to you. Okay, so if you've never drafted a will in your life, you can't charge $7,000 for your first will because it took you a whole long time. You know, what's customarily charged? You know, what they get away with in Fairfield, Connecticut, I don't think $1,200 an hour down here in South Jersey would really fly. You know, the experience, the reputation of the attorney and the law firm. You know, and this is a good time to get into a topic that was brought up at one of my last sessions, and this was, what is a reasonable expense? Now, by the way, in hearing this lecture today, or if there's other areas in your practice, in the fee aspect that you have questions about, you're thinking about a new kind of fee, please email me, because I would love to get to help you out, in terms of doing research for it, because all the research I do, I just take out and teach other people. So at my last session, some people really brought this up, like, well, can I charge for my secretary? When does it become unethical for me to start charging? Well, I always start my research in New Jersey with the Gann publication. Is it Michelle, M-I-C-H-E-L? Got a wonderful, wonderful book. And then I go, Dave Dugan has got Through Ickle, wonderful new book out. And you combine that with your RPCs and the internet, and we can get something together. Now, first of all, here is what I have found, is that basically in your expenses, there is a lot of latitude in what you charge, as long as you have disclosed it to the client in writing. So let's go through the types of things that we might charge for. Okay, normally the cost of our library, the cost of our utilities, our rent, we consider that overhead and don't pass through to our clients. Although one of the articles I was reading, written by an in-house corporate magazine, and it was warning about those lawyers out there, what they're doing. Apparently there are attorneys that are charging for air conditioning, so that when it's, and that's what they were saying, your attorneys will even charge for air conditioning. Now, let's talk about what would be considered to be reasonable, because RPC in New Jersey, RPC 1.5 does not address the issues of expenses. So where you really have to go, we have an ABA. There's one case in New Jersey, the Ryzen case, that I think is a little bit off kilter, because it's basically saying, oh, you can't charge for photocopies. I kind of think that's crazy. So let's go to the ABA.
Is that the rule? Is that the rule in New Jersey? You can't charge for photocopies?
No. And this was in Michael's book. He talks about this Ryzen case. And, basically what it says is that, photocopying, I think maybe in this case there might have been a lot of egregious charges that kind of made the court go one way. But here's the opinion, that's an ABA opinion that I really look at, because I don't see anything else in New Jersey. You've got its opinion 93-379. And that is not cited in your materials. It's ABA formal opinion 93-79. And what this opinion does is it breaks down the type expenses into 3 different categories. It says always keep in mind the reasonableness requirement is what dictates what you can charge. So let's look at general overhead. It says, look, in the absence of disclosure to the client, you're not going to be charging for overhead, for maintaining your library, all that kind of jazz. And I think most attorneys would not be thinking along those lines. Now you get into disbursements. Most of your retainer agreements probably say and all costs, including stenographers, photocopies, blah, blah, blah. Filing sheets, without really setting forth what the basis of that charge is. And as long as you are just passing through your cost to the client, that's okay. You don't have to specify it. But if you're making a profit off the client for the disbursement, that's where you must disclose. So that for the messenger service, that charges you $19 and you mark it up to $25 because you had to call them, you got to disclose that to the client. Now, what about, and also, if you receive a discount from a third-party provider, I think it starts getting a little bit difficult if in your phone bill, your overall phone bill, you get some massive discount at the end of the year. How do you allocate that? I'm not sure. I think that gets pretty messy. Now, what about in-house provision of services? I got a question last week just about, well, what about my scanning? Can I just allocate, my scanning costs? Without an agreement with your attorney or with your client, I don't think you can just do an allocation. Well, I got 300 clients, it costs me $300 a month, so I'll charge $1 per client. I ran across and I have not analyzed this for the ethics of it, but this guy was really right out front in terms of how he's charging for expenses. And the fellow's name's Gustafson. It is Gustafson Law Office, GUSTAFSONLAW.com. And he has got a whole panoply of costs that he charged for. Just telling about how many gigabytes that we use, you're going to be charged. And he doesn't seem to have any problems with it. So that would certainly be wise, that if you are going to charge for overhead and this type of thing, or make a profit on disbursements, that you are letting the client know that. Because, and what the ABA opinion says, it says that, while you can make a profit, it cautions the lawyer's stock in trade is the sale of legal services, not photocopy paper, tuna fish sandwiches, messenger services, or computer time. So that is what the ABA has to say to us. Don't pad your bills. Keep your real time. If you're billing by the hour, if that is your agreement, then that's the way that you need to bill. I know of many attorneys, because I've been their adversaries, who charge their wealthy clients a lot of money because they got a lot of money to pay. I remember one particular case, in a guardianship case, where I was actually had the lion's share of the work, and at the end of the day, at the end of the case, because we all had to file our fee applications, my fee was $3,000, which I thought was pretty reasonable, and my adversary's fee was $11,000. And I thought, wait a minute, I did all the work. How did this happen? So not everybody is as meticulous in their time. And take a look at the McCock case, M-A-C-A-K. And in McCock, this was an appellate division case, and the attorneys had already been paid for services that had been rendered up to, at the end of the trial. Well, or at the end of the hearing. And what the court said is, pay very close attention to the fee applications that are sent on remand. And in the footnote, it said, we don't understand how $50,000 got billed to this guy, because there weren't any briefs filed, and there just really wasn't a whole lot of work to do. So how did 50 grand get run up? So even the appellate division is looking closely at fees, and so should you? Now this one's under the category of absolutely unbelievable. Attorney Kristen Stallbush of Ohio was a billing machine. He's a court-appointed attorney. This woman had such a good heart for all these people. She billed in 1 year 3,451 hours. Wow! How did she do it? She never slept. There were 3 separate days in which she billed more than 24 hours in a day. I'm not sure if it was daylight savings time. Did she, fly to the dateline, the international dateline? I don't know how she did it. Another period that was pointed out, in a 144-hour period, she billed 139 and a half hours. Well, she ended up saying, well, my bookkeeping, not so great. Then there was this whole blog that I follow. There was a whole debate. One guy who teaches management to attorneys, he came up and said, he wrote in and said, it's the law school's fault. They should have taught management. And I think she had a little bit bigger problem than that. So she had 2-year suspension, 1 year state. So that is lawyers gone bad. Now, what about allegations of excessive legal fees? And I don't know, we're not in a, about you, I mean, I know we were in a recession, we're apparently not in a recession any longer, but times are still tough. Lots of hungry lawyers out there. So now, a cottage industry is developing in certain circles to review other attorneys' bills to determine if there's excessive legal fees. Well, here's a matter. Where does this come up? The excessive legal fees. It's when you file the suit. I mean, that's usually when you sue your client for fees. That's often where this comes up. Well, that's exactly what happened in the Zafferman case, which alluded to on page 12 of your materials. Now, in Zafferman, of course, lawsuit filed, malpractice suit. Ooh, one of the counts was that there was a misrepresentation of the experience level of your associate. Now that gets kind of scary, because think about it. Think about an attorney and a client walks in the door, and by the way, that was a fraud count. So a new client walks in the door. It's your first day as a lawyer. You know, do you say, "Oh, yay, you're my first client"? Oh, see, oh, yes, we've handled these types of matters, certainly. Gee, does that give rise to a fraud count? I hope not. Well, in this case, another count was billing irregularities. That was part of the count in the malpractice. They said it charged excessive fees for work performed. So what kind of testimony, what kind of evidence? Well, the defendant got up. You know, I don't know, well, that's what I think. And, you know, probably said, oh, none of my friends had to pay this much. Whatever people say when they're mad about lawyer fees. And the court said, no, you got to have more than that. We're going to need some expert testimony. And certainly that's always a good thing in defending a claim for excessive fees as well. Because basically what the court said is that these types of claims, they don't fall within the common knowledge doctrine, so you got to have an expert. Now, non-refundable fee arrangements. Okay, that's when you say, all right, I'm going to charge you 10 grand up front, and you're not going to get any of your money back. You know, can you do it? Can you do it? Maybe. New York, no. New York just came out within the past year. It says no non-refundable retainer agreements. Now, and it's a hot topic. It's a hot topic throughout the country. New Jersey, they have a New Jersey Advisory Committee Opinion 644 that really lays out a nice roadmap, and it's still good law. It's still good. And then in matrimonial practice, absolutely forbidden. And by the way, for most of you, if you're a matrimonial attorney, you know where the fee agreements and matrimonial agreements come 5:3-5. Take a look at that. That'll tell you how you can charge in matrimonial areas. See, the opinion 644, there are some cases that non-refundable is good, is okay. Because if the attorney is standing there ready, willing, and able to perform the work, and it doesn't materialize, the attorney's been ready, willing, and able to perform the work. I know.
Sure, not doing any other work.
No,
just waiting for that case to be ready, right?
My practice has never quite got that busy. Our rule of thumb is if we didn't do the work, we didn't charge for it. Well, they talk about that in certain circumstances, it could start out being fair and reasonable and then turn into an unreasonable fee. And when would that be? When your client dies. Okay, we had, in the elder law practice, it was a flat fee up front is how we charged. Well, these people were in nursing homes. They were really, really sick. And it would not be at all unusual for a family to retain us and then for mom to pass away 2 weeks later before we got a substantial amount of the work done. And anytime this happened, we would look at it, look what we did, look at what the fairness was in this, tell the client what we thought was fair, and we never had a client say that they didn't think it was fair. I think they were just happy they were getting money back, which is just such a sad reflection on us. Now, let's talk about a case in New Jersey on non-refundable fees. It's a fellow most of you have heard of, Elliot Gorvitz. Now, Elliot, just a phenomenal career as a matrimonial attorney. You know, all kinds of, president of this and that. Well, he started getting a bad name when he fired his secretary after 25 years because she had cancer and disfigured her face. And she got a $750,000 judgment against him, against the firm, and the firm went into receivership. So that wasn't good. But then these ethics complaints started surfacing on the non-refundable. And basically what it says, in the event the amount of time we spend on your case and the resulting fee generated is less than the retainer that you gave to us, then the unused money will be promptly returned to you, except for a minimal non-refundable retainer of $5,000. So one lady came in and said, yeah, I want a divorce. He said, okay, $5,000 for a retainer. So she paid $5,000. She called back the following week and said, I got good news. My husband and I are working it out. So, we haven't done anything yet, so I want my money back. Well, more than 3 years after the initial payment, and with help of counsel, Gorvitz firm refunded $1,275. And it's no wonder that he was found to have violated 1.5A as well as the matrimonial practice, and they said, oh, what the heck, let's just throw in a little 8.4A as well. And he got a reprimand out of it. In another case, which I still didn't figure how he even took this case, was a woman came in, and it pertained to something to do with real estate down in Maryland. Again, $350 consult fee. Okay, that's fair. $5,000 retainer. She called back 2 days later, said, oh, I found out I need a Maryland attorney. I don't need you, I want my money back. Well, it took him 6 months to get the money back to her. Gave half 3 months later. What, was he using it for overhead? I mean, for goodness sake. Well, this is where you always have to keep in mind another RPC to be aware of when services are terminated is 1.16D. That sets forth exactly what you got to give back. And what's one of the things you got to give back? Money. Now, again, we already know every new matter, no matter if it's an existing client, that you must sign a retainer agreement. And think about this. The retainer agreement does not just talk about fees. The retainer agreement talks about scope of representation. Okay? This is what we are going to do for you and no more. This is where it stops. It lays out, it gives you the opportunity to lay out what's your responsibility as the client and what's my responsibility as the attorney. So, for example, one of the clauses I had in my retainer agreement is somebody from our law firm will get back to you within 48 hours of your phone call. Now, it doesn't say me. It may be an administrative person. And then we put a further clause that one of my routines would be to make phone appointments. We encouraged phone appointments. Put it right there in the agreement. And then people pay attention to it because it's a contract. And speaking of this being a contract, I'm just really amazed when I see the retainer agreements developed and signed by some lawyers, They're all crooked, faded, the photocopy job is sloppy. That is your first piece of paper that you are, the first legal document that you are handing over to your client. Don't you want to put your best foot forward, even in a retainer agreement? Now, you want to put a no guarantee of success clause. I think most of us have one of those in ours. I've got a sample in there. Like, hey, we're going to try our best, but we may not win. You want to lay out the stages of the case, and particularly in your tiered arrangements, where there's a flat fee for part 1, another flat fee for part 2, another flat fee for part 3. You want to really lay it out and specify when does tier 1 actually end, so that there is total clarification. What is your retainer policy? By the way, there are certain circumstances, of course, in your contingency cases, in a state administration. If there was a will contest or a state administration, I knew there was a fund of money there, so I knew I was going to get paid. You always get paid on those. But otherwise, just remember that Fuenberg, curve of diminishing appreciation. Get the money up front when they really know they need you. They need you all along, it's just they may forget it throughout. Your grounds for withdrawal, be sure that you set those forth in the agreement. And go back and look at your agreements from time to time, and even an agreement with a particular client. When I had a bad acting client, a client misbehaving, how did my clients misbehave? By not giving me the paperwork that I needed to move forward with their case, because they expected me to come to their house and look for it. I don't know when that would happen. So we would have in the agreement that these would be grounds for withdrawal if you don't supply us with the papers that we need. And then if a client was not being cooperative, it's a perfect time to write a letter saying, well, you're being uncooperative, and under section 1.8 of my agreement, this is grounds for discharge, and blah blah blah. And if you want us to continue representing, then start doing what you're supposed to do. And it really does work, because clients don't like to be called to task for breach of contract with their attorneys. Now, what about paying the costs? We've already talked about the payment of costs. Make sure that you've got a strong agreement about who pays and when is it due. I mean, you're not a bank. And tell me, in the personal injury area, I think it's pretty common that attorneys bankroll the litigation. Does anybody else have a different opinion on this? Yeah, and I know last week when I spoke at another firm, that was one of the frustrations. And I'm like, hey, if everybody doesn't stop it, then most people are still going to continue doing it. It's our culture. And I don't know, there'd probably be an antitrust violation if we took that and added the law journal and said, hey, everybody, wanted to stop paying costs. Also, with retainers, with a retainer for a fee, is it an evergreen fee? Like, do you have an evergreen retainer? Once the retainer gets down to a certain amount, do you require a replenishment of the retainer? Same way with if you have a separate retainer for costs, do you always require a replenishment? In your materials, there is some samples of how to handle these types of situations. Your scope of representation, that is where you have the biggest opportunity to make a difference with your representation of the client. We're going to get into a few moments the types of unbundled arrangements. With scope of representation, where does that come up? Well, the statute of limitations is run. And the client said, but you were supposed to. And your defense, no, I wasn't. So how do you get that defense with your evidence for that? Your written retainer agreement. 41 states have allow you to limit your scope of representation. New Jersey, it's RPC 1.2C. Now, so for example, if you're a workers' comp attorney, you may put that there could be a third-party claim, but we don't evaluate that. Because that's where comp attorneys can get into trouble, missing a third-party claim. You know, future corporate minutes. Okay, so you incorporate somebody, and then 20 years goes by, and they say, you didn't do our minutes. You know, pierce the corporate veil. And you say, well, our agreement didn't say so. Be very clear. And if you think about it, that's a way to really ensure that you will continue a stream of revenue to send the clients a letter every year. Hey, you need to have this. It's not under the scope of our original agreement. You know, another $250, $300, whatever you're charging these days for those types of things. The seminal case in New Jersey is Lerner v. Laufer. Now, in the Lerner v. Laufer case, the situation was the husband and wife were getting a divorce, went to mediation. Now, when the mediation was all said and done and they had they agreed, the mediator said, look, you got to each go get separate counsel, which they did. Well, a representation had been made during the during the mediation by the husband. Nah, my company, it's not going public. There's no plans for that. What happened 2 months after the divorce? It went public. Well, who did Mrs. Laufer look to first? The attorney. Because you know, everything's always the lawyer's fault. So she filed a suit, alleged malpractice. Now, here's what gets interesting in this case. It's that when the client came in and there was a written engagement letter, it's given to her. It says, I have not conducted any discovery on your behalf. I'm not in a position to advise you as to whether it's fair and equitable and as to whether you should execute it. But then he sent one of their standard agreements to her home, and it said that the services are to include factual investigation. So I'm sure that when Mr. Laufer or when Mr. Lerner saw that, he went, oh no, you know, I hate that. Well, here's what happened. The court found in favor for the attorney. And part of it was on the stand. The lady testified, yeah, I knew he was just kind of looking at it, giving him his blessings. But this is really the case that stands for the proposition that, yes, under 1.2c, you can, your standard of care is not breached if you have limited the representation in writing. Now, once you do limit your representation, don't go out of that scope unless you get a new written retainer agreement. Because then arguably you can say, oh yes, well we had an agreement. There's evidence that you went out of the scope. That could cause you some problems. Now, recent case 2007, the Lolio matter. In Lolio, he represented the state administration. Well, at the end of the day, it's like goodbye, the state's over. The state taxes were due and owing. The client cashed in IRAs and paid the estate tax. Well, there were other assets that could have been used to pay that estate tax. If you cash in an IRA, that's an immediate income tax that year that you cashed it in. And so when the client found that out, blame the lawyer, sued the lawyer. The lawyer said, whoa, wait a minute. I was just the estate administration lawyer. The way that you were going to pay those taxes, I didn't have to give you advice on that. The court said no, there was no clear language that limited that scope of representation. Now, you get into there's again with this, particularly with this challenging economy, Lawyers are the last people that you want to pay. So, what are people doing? Do it yourself. Now, by the way, if any of you think that people are not trying to do it themselves, you're going to be shocked by this. The month October 27th, 2010 to November 25th, 2010, there were 406,000 people. 406,000 people in 1 month that hit the LegalZoom website. That's a lot of people. A lot of people wanting to do it themselves. I have a friend who, you know, she thinks she's mini lawyer because she's, you know, she's owned a lot of properties, you know, had a lot. So what does she do? I heard her on the phone. I come up on a vacation with her. She was just taking an old figure or an old real estate contract that had been used in another one. Yeah, we'll just use this one for this one. I mean, yeah, I didn't say a thing. I'm not a real estate lawyer. I'm like, hey, whatever. But people, they just think they're so smart and can do this. So this leads then to a devaluing of your worth in the client's mind. So what does the client do? The client comes in and says, look, I'll do this part A, I only want you to do part B. That's unbundling, okay? You've got then ghostwriting pleadings that comes in. You know, not document review. I'll just come and do this one little thing. I think there are some areas that I think is absolutely works excellently in. I know Gary Borger is doing a lot of the collaborative divorce, where where basically what happens is that the husband and the wife sign an agreement that they will not, that they agree to settle this matter, but that if they don't, the two attorneys representing them in the collaboration, in the mediation, will not be representing them if it goes to litigation. So that can definitely run up fees. So I think that when you have that type of a structure, I know this has been well thought out, that this can be a good thing. But it's the other things that give me pause for concern. Because one of the arguments against the unbundled model is that, okay, so you send the client away with these nice pieces of paper, maybe they won't follow through, maybe they'll do the wrong thing. I think it opens up a lot of potential problems. And in New Jersey, when you get to the ghostwriting, you know, and no good deed goes unpunished. Because there was a case at Delso, 2007. What happened in Delso was that an attorney ghost wrote some pleadings for someone and was found to have violated RPC 3.3, which is candor to the tribunal.
What do you mean ghost wrote?
What? That just wrote the pleadings. So the person came in. The statute's going to be blown.
A client
came in, and look, it's probably sometimes a cousin or a friend of a friend, an old client. So, and the attorney says, well, I mean, it's going to cost you $10,000 to retain me. Well, I can't afford it. Can you just file the answer? Yeah. Can I file? Okay, I'll file the answer for you. Okay, I'll just file the answer. That'll be it. I'm not going to do anything else. But here's the answer. Here, secretary, put pro se. Just see you later. So that's what happened. Something similar in this case. So now we have opinion 713. January 2008. It gives you the roadmap for ghostwriting. And it's the issue of disclosure, candor to the tribunal. So here's, for those attorneys that are not too busy with their lives and just want to do work for free in ghostwriting these pleadings. Of course, if you work for one of the nonprofits, yeah, that's going to be allowed. The second one is that if you are simply trying to assist somebody who's financially unable to hire an attorney. So if that's the reason, you do not have to disclose. But if disclosure is required, if the client doesn't want to disclose to take advantage of, judges apparently, give a little bit of lax to leniency to pro se, or and basically what you have to put on there is your name and that within the scope or limited scope of representation, I draft this one pleading. I personally wouldn't get involved in that myself. Last week there were a couple people that, I mean, they have their pat language of what they put in the retainer agreements. I mean, they were telling me what they put in theirs. It really wouldn't be for me. Look, I think it's good to give people access to the system. But any comments on that? Yeah, I can see it makes some of you nervous as well. Now, if you are going to ways to define scope of representation, you know, how many meetings are you going to allow? I mean, that could be a good way to combine a flat fee with an hourly rate. You can say, okay, on this flat fee, this includes 2 meetings, any additional meetings, and it goes under the hour. So there's some very, very good things that you can do on that. One other thing is that in this unbundled services, is that you're really, it's not just your brick and mortar offices. There are attorneys now that have virtual offices, and that they don't even have an office building. There's a fellow down in Florida. He's a Maryland attorney, and his website, it's Richard Granat, Granat. If you take a look at his website, and basically there's ports in there. People just get in there, you know, for their own pleadings, you know, kind of like fill in what they need. And he never comes up and makes an appearance, so it's all on unbundled. I guess probably the guy wanted to retire, said, hey, I've got all these forms, and had some techie set up the service form. But you know, you really get into, with these virtual offices, you've got to be really careful, the issues of confidentiality, you know, because with all everything out in the clouds, you know, where is it? You got to make sure your service provider is really got everything buttoned up tight. The ABA has a nice handbook on limited or unbundling of legal services. Now, there's a lot of clauses that you need to avoid. I'm not going to go through them one by one, but let's just suffice it to say that if you look on page 19, that there's the list. Like, so, you know, if you think you may have a high media case, you're a case that will be attractive to the media. You know, you can negotiate to have the media rights of your client. Right, I just finished reading Michael Connolly's new book, The Fifth Witness, and like on about page 20, he was negotiating rights, and I'm like, wait a minute, 1.8, you know, I can't have any fun anymore, you know, reading these novels. You know, obviously you can't limit your malpractice exposure. There's an agreement that was brought, an unreasonable agreement attacked in the Cohen case, page 19 of your materials. Well, in this case, this 1990 case, the Cohen was representing was being represented by an attorney, and this attorney charged $100,000 a year retainer. The client was happy to pay. It said, and if you don't want us the following year, you have to tell us 6 months ahead in writing. Well, on December 10th, 1989, the client wrote, we don't want you next year. And didn't pay the $100,000. Well, what did the law firm do? I mean, they had the guts to sue this guy, which I think that takes major nerve. So sued him. And the court, what do you think the court said? No, violation of public policy, thus unenforceable. You know, there's some of the things that when I'm researching for these sessions, I know every once in a while I'll get a comment like, oh, that point was a little too basic or whatever. Well, obviously these points aren't basic at all, because attorneys are still out there violating these provisions. Non-engagement letter. Okay, I found non-engagement letters. I had a process in my firm that, you know, when a client came in for the initial consultation, there was a little form I filled out. And then if they didn't retain, you know, unwisely, then it'd be like, no, retain. But there was always a follow-up. You know, if the client at the end of the session, you know, either I said, well, we're not the law firm for you, or you don't have a case, or you should go to this person, or whatever. Okay, then we close it. But then there's the ones where, you know, of course we love to get the check the first day they come in and get retained, and sometimes that happens. But what about the rest of the cases? We think, yeah, get back to you. So what do? It's up to you to play the proactive approach in following up with the client. So my message then at the end of the session was, okay, I would say part of my job is to motivate you to move on to protect your legal rights. And I'm not one to harass you. So if you decide you don't want me, it's okay to say no. But how long do you think it's going to take to make the decision? Let's say it's usually 2 weeks. You know, of course, unless the statute's going to run tomorrow. And so it's 2 weeks. And I said, well, okay, if I haven't heard from you in 2 weeks, is it okay if I give you a call? Well, not rarely did people say no. Okay. So then, you know, then you call and they, you know, caller ID, they don't pick it up. And so then what do? Send them a non-engagement letter. And let me tell you, with the non-engagement letter, I would always put, your file is now closed. If you wish to discuss, we would get calls. No, don't close the file. We want you. So it's a way of really inspiring the client. So from a business perspective, it's good. But let me tell you, from a protection standpoint, it's excellent.
What happens sometimes is you have meet and greets, and that the clients come in and they're not sure if they want you to represent them, and you're not sure if you want to represent the client. And you know, you say, I'm not going to give you legal advice. I'm here just to find out what it's about. You don't take a retainer. You don't, you know, indicate you're being engaged in any way, and then you know, people part their ways. You know, that's usually one way to handle it. I mean, I wouldn't generally send those clients a letter saying, you know, well, we had a general conversation. You were evaluating me. I was evaluating you, and you didn't decide to proceed. Obviously, if it's a matter where there's a statute of limitations running, I mean, you got to send a letter. You got to say you didn't engage me. You know, I'm not engaged, but it's just general business matters or the like. You know, that's what
I think it's safest to look. In a perfect world, I think everybody would be sent one of these letters in a perfect world. And yeah, you can go a little bit overboard. You know, up here, I really do recommend though that as often as you can to send non-engagement letters.
The harder part is the disengagement letter at the end of the matter, because it's not always clear when it's over.
It's not.
You know, just you have a client that's a business, they use you for vendor contracts, internal agreements, you're always ready to pick up the phone and do their work, so it really sort of never ends.
That's an ongoing, and I would think that, look, that's going to be on a case-by-case basis. You know, you may, if there's been one transaction that's complete, you know, hey, we finished it, do you see any loose ends? That could be a good way to protect. Like in the real world, most is okay. Hey, yeah, no, nothing else on that. Okay, thanks, goodbye. And then you make your note, talk to client. You know, at the very least, make a note of your conversation. I mean, that's evidentiary as well. There's a case, a recently decided case in New Jersey where an individual, pro se, had filed his case, it got dismissed. He wanted to have it reinstated. Went and met with the attorney and had several meetings. There was no signed retainer agreement. And then it became too late, and the attorney had never made the filing. Lawyer said, well, no, you've just been in. I mean, I didn't say I was going to move forward. The court found in a malpractice case found against the fellow. So I would tend to be as conservative as possible.
Love the client that comes to you the day before the statute of limitations.
Oh, I know. And you got it. It's just like a boss that, one of my first bosses as an attorney, everything was either an emergency or a roaring emergency. And, you know, hey, if the statute is about to run, well, I don't know. You know, again, the non-engagement letter and the disengagement letter, use them very liberally. Because with your disengagement letter, you know, even like you get your $1 million verdict for the person, still send the letter. Just send it, because think about. I always think about also the marketing aspect of it. Okay, every person that breathes is either, and actually when I was in the estate planning, they didn't even have to breathe. Is that they're either a potential client or they know somebody who's a potential client. So someone that comes in for just the meet and greet, why not put them on your database? And then when you're sending out a firm letter at the beginning of the year, then all of a sudden now they're on your database. Or if you're going to put on a little presentation or whatever it is you're doing to market, that's just one more person that met you and maybe had a favorable impression of you. So that's the same way I use disengagement letters. Is that in my disengagement letters, I would do a client survey. You know, what did you like about us? Sometimes people fold them out and send them back, and ask for a referral. Just have a little sheet in there. You know, we asked for your referrals, and could you fill in someone's name? And often people did. So we would get new clients like that, and boy, every single little bit helps. Now, fee sharing arrangements. Now, obviously, the defendant who pleads their own case has a fool for a client, but at least there's not going to be any problem with fee splitting. There's two issues. You've got fee splitting with lawyers and fee splitting with non-lawyers. Under what circumstance can you split fees with non-lawyers? Anytime? Can you do that? How about someone brings a personal injury case into you? Can you pay? No, you can't do that. Here's what you could do. Is that
trick question.
Is that if there's one of your partners passes away, and you know it's part of a payment of an estate, a buyout, or you have a staff working for you, contributions to pension plan, profit sharing plan, that would be allowed. You know, we talked earlier about that. Sometimes we learn our ethics. It's kind of like I envision the paper cup and the string. You kind of pass it back and forth. Yeah, it's okay. You know, that's what my partner told me. It's all right. Well, we see then that within a particular firm, you can have these institutional ways of doing things, and that's what we found with the Tomar Siminoff firm. And that was a Camden County firm, and they had a long history of paying basically what it sounds to me like runners, paying people to bring cases into them. And it was long practice to paying their employees. Well, they cleaned up their act, and actually they stopped it on their own, but then ultimately somehow got caught. Well, it came out that there were referral fees paid to a Mr. Buccilli, who was their Northfield office manager in 1 year. And this is 1 year. $807,000. Okay. Now, you know, that may have been the old way of doing things. I got to tell you, having practiced, and I know there's others in the room that have practiced a while, 30 years ago, things were different. Things were looser. It's not that way now. So don't do it. No way, no how. Well, despite this seemingly obvious rule, there was just a recent New Jersey Advisory Committee opinion, number 716. And this was 2009. What it was, it's in we all know lots of foreclosures going on. Lots of then the loan modifications companies. So what happened is that attorneys and loan modification companies were, wanting to have arrangements with attorneys and saying, look, all right, look, we got these clients. you attorney, you negotiate the loan modification and you get paid. There were 3 different ways presented of the attorney getting paid. Is that either the client can pay the attorney, and the attorney pays the referral source. The referral source gets paid and pays the attorney, or there's 2 checks, one to the attorney and one to the referral source. The court or the ethics opinion was absolutely not. This is fee splitting, plain and simple, not allowed. And by the way, if there is somebody, because think about what happens, is that then it gets a little bit murky, you know, is there's a little unauthorized practice of law there. Because here's what I saw, is that as an estate planning attorney, I was approached, I'd say 3 or 4 times in my career by, you know, so-called trust mills. I think a lot of them were annuity companies. They were trying to sell annuities. And what they would say is, look, you never even have to meet the client. Okay? We take all of we do the due diligence, we give you the information, you just spit out the document, we'll get the document signed. And they were going to pay me $250. I mean, that certainly is an attractive deal. And to many attorneys, that would be. And I think it goes on a lot. Don't get involved in anything like that. And by the way, the other fellow, that's unauthorized practice of law. And that's a 4th degree offense. It's under 2C:21-22. So, not good. A recent case, Garrett Lardier, Point Pleasant guy, and he got involved with a Vermont-based company. And basically what happened with this is that there was a sharing of fees, like they were finding people for foreclosure suits, and there was a sharing of the fees. And the guy didn't get disbarred, and basically they didn't suspend him. They said, he's not venal. The ethics committee must have been in a good mood that day. Rather, he has a distinct lack of knowledge or a lack of understanding about his responsibilities as a member of the bar. Don't depend on that as a defense at all. Now, what about can you share fees with other attorneys? Well, we know you don't share it with non-attorneys. What about with lawyers? Okay, look at RPC 1.5E. All right, now with your partners, you may not really want to share it, but you got to go according with your agreement. What about to outside attorneys sharing of fees? Well, of course, you know, we've got our certified civil trial attorneys. Then certainly, that's a rule that in New Jersey that allows specific fee sharing. It is okay. But what about if the person just goes to the wrong law firm? And you know, you start the case and you say, wow, this is more than what I thought it was going to be, or different than what I thought it was going to be. And so you refer it out to your colleague who does this kind of work. Well, can there be fee division in that type of case? Maybe. So if you look at 1.5E, first of all, the client can't be responsible for paying more than what they would have paid, you know, in the first place. And it's like the division of the fee has got to be in proportion to the services, or if the client agrees, it doesn't have to be in proportion to the services, but each attorney has to have joint responsibility for the entire matter, which would be pretty unusual. Maybe sometimes you call in co-counsel. From time to time I would call in co-counsel. Then of course the client's got to know, and there has to be consent. I've put in here a sample clause, or actually a sample agreement, that if you are going to have a fee sharing arrangement with a firm that you're sending a matter out to that really meets the 1.5E standards. Now, what about having a third person pay for the fee? In the elder law context, that happened all the time. Having third persons. And basically what happens is that if the client consents after consultation, the attorney has to maintain his independence and also has to have a confidential relationship. So think about the 17-year-old that gets pulled over for a DUI. Wait, do you have to be 18 in New Jersey? I don't have kids. You have to be 18 to drive. So the kid, how much, 17? So the kid gets pulled over, and the parent brings the kid in, and is going to be paying for the fee. Now, does the parent automatically get to sit in on the, no. So how do you deal with that?
Bring them in, tell them the whole thing, give them the whole scoop of what's going to happen, and then after I finish, Mom and Dad, would you please leave? I need to speak directly to him. And if they have a problem with that, then I don't represent them.
Then that's exactly the right way to go. It's, I ran into that with the elder law a lot, where even though I didn't necessarily want to have the whole consultation with the elderly person, because they really want the person that had the knowledge. I'd say, okay, look, I gotta have your kids leave the room, and I tell the kids ahead of time. So often the parent will be scared. Not that they were so scared of me, I don't think, but they're just scared because they're elderly, away from their kids, and so often it would be the parent that you'd have to talk into letting the kid leave the room. Now, what about our legal fees deductible? Well, I don't know about you, but I always like to rely on the advice of an accountant. Anything that had to do with income tax issues like that, I'd say, well, just talk to your accountant. But your general rule is, any fee to enforce an alimony award, tax advice, and the like. Now, what kinds of issues do you see in your practices with collection of fees? Or with setting fees?
Collection, I don't get them, so. That's an easy issue. And I don't sue my clients because I think it opens up a can of worms.
There's a blog, William Voorhees has a wonderful blog, and according to Voorhees, 50% of malpractice cases are counterclaims. So, what about it? Yeah.
We have a lot of set fees. We have, fortunately, a lot of long-term clients, and so we've been able to establish some kind of idea of what the annual revenues might be, and said that, but it's only an idea, and so it can be harmful sometimes, because if issues arise in the course of a particular period of time that we did not anticipate, we're stuck with the fee that we agreed to. And it seldom works the other way around.
Right.
But it is it's an assistance in terms of cash flow and knowing what's coming in and what you have to budget for.
Yes, it's nice to have that regularity.
Right.
And maybe you could put it in an agreement unless you're just not wanting, unless it's a matter of good client relations.
Yeah.
Then you could always put a clause in there that this covers only X, Y, Z, and if certain things come, you could do that. Sometimes I think attorneys hesitate to because you.
It's better. We found that it's sometimes better for the long term to keep that. We can swallow a little bit for the sake of the future.
That would be my attitude as well.
Mm-hmm.
You have a question?
No.
Yeah, I guess my attitude about the fees, I never got real, I didn't charge a lot. Our fees were reasonably high. I think we did good work and charged accordingly. And I didn't want to nickel and dime my people. I didn't want to nickel and dime for photocopies because it was a large enough fee as it was. So, but I know other people that are just every step of the way charged for every single dime, and I don't think. Do you like to be nickel and dimed? I don't. I'd rather maybe write down this is what it was, and then give them a discount. See, people love discounts. Give them that.
Well, normally what I tell them if it's like under $50 in cost for copy, I just eat it.
Right.
But I had one that the meds were god awful. It cost me $280 to copy.
Yeah.
Well,
Yeah, that's a
you had,
challenge.
So then they had to pay for that. But yeah, I try to eat a lot of costs, but let them know you're eating it so
Yes.
that they appreciate it.
That's right.
Because they take you for granted if not.
They absolutely do. And I think that letting them know in writing that you are, because it is almost like a little Christmas card when they get that type of bill. Now, what about suing for fees and your pro se? Case recently decided in New York. It was the Vinnick matter. Okay, Vinnick sued his client for close to $70,000 for $76,000 for fees, and said, "Look, I'll do an offer of judgment. Okay, $63,500 I'll take." And the client said, "No, I'm not going to pay." Well, the attorney won on a pro se basis and said, "I want my counsel fee now, $49,000." So I get my $76,000 plus I get $49,000. You're gonna love the appellate division. It says 4:58-1 provides that a successful litigant shall be allowed counsel fees, and the fact that Mr. Vinnick was pro se did not matter. So that's a good result for the home team.
The problem is no one is suing for their legal fees. In this environment, it's malpractice carriers don't like to see you doing
They
that.
don't, and that's what one of, if we haven't already got to that slide, is I do not recommend suing for fees. Now, you get to $80,000, $120,000. Would you sue for $5,000? No. Would you sue for $120,000? I don't know. I would hope that I wouldn't have let it got to that. And that's where the retainers. I don't know why people aren't getting retainers. How do we get these runaway fees like this? Well, there's a recent case that, in fact, just decided January 24th, 2011, the Pareca case. In Pareca, a lawsuit that was settled. Settlement agreement did not address counsel fees. There was a fund, but no fee shifting. Well, then a motion for fees was filed after the settlement. So, what do you think? First of all, is that something that you would normally do? Another litigator that I talked to about this said, "Oh yeah, I see that done all the time." I was over in Pennsylvania, though, so I don't know. So the plaintiff filed a motion, said, "I want attorney's fees." And you know what the defendants say? We have a settlement agreement. Well, the appellate division said that while there's a viable claim in the fund in court exception to the American rule, remains to be determined. They remanded it just to get more facts as to what the intent was. But boy, if you want some entertaining reading about and you don't want to be referred to like this, the court said this plaintiff's attorney was lying in wait. You never want to be accused by the appellate division of lying in wait. Now, what about disgorgement of legal fees? That's also an issue that's coming up to the forefront. And it comes in the context of a malpractice matter, legal malpractice. So the malpractice suit's filed, and then there's one of the counts is seeking disgorgement of fees and forfeiture of fees not yet collected. Well, New Jersey just really doesn't have clear guidance at this point as to whether the disgorgement. Now, the national trend, though, is to allow the disgorgement of fees. But the trend seems to be that it's only for the compensation received for the services that were negligently performed. Now, I'd like to talk to you about a few other items that I've run across. In fact, just in yesterday's Law Journal, there was a case reported, the Nostrami case, Nostrame. Well, in this matter, what happened was that Nostrami was the original attorney in a personal injury matter. And the client fairly quickly said, "Oh, I don't want him, I'm going to go to somebody else as an attorney." This unfortunately happens from time to time. Well, when the $1.5 million judgment came in, attorney number one, Nostrami, was paid his $11,000 that he had claimed. But he went ahead, he sued the second attorney in the case for fees. And here's what his cause of action was tortious interference with contract. And basically what the court said was that unless you can show that there's been wrongful means used to induce the client, no way. But so that case was just reported this week. Now, what about real estate? Do you have to have a contract? Well, we know that you have to have a contract. But there is a case just handed down June 9th, 2011. Well, here's what this guy did. He inflated the cost of the title insurance. Because he said, well, some other costs to come up later, and I don't think the client would want to give me a retainer for those costs, so I just added it on to the cost of the insurance. Well, then in the course of the whole deal, what do you think that the ethics committee said on that? Nah, big thumbs down. Now, then what about the fact that there was no written agreement? What the attorney said that, oh, there's time constraints and pressures of the real estate market, so I certainly am not good, I certainly couldn't have been expected to have signed a retainer agreement. The court said, no, new client, always, 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 you gotta have a retainer agreement. Now, before we move on, I'd like to talk to you about really what you've got out of today's, because we've got 15 more minutes, and I think it's useful to kind of review what was useful for you and what you would have liked to have seen more of. What kinds of questions do you have? We have an evaluation sheet that I do need you to fill out. Under Pennsylvania rules, I am required to have the evaluation sheets. Now, well, come right on in. Come right on in. You can have a seat. Pull the seat right up over here. This is actually a great time to introduce Joe Myers, who sponsored today's session. I now tell him I said all good things about him. There was all good things. So we'll let him have a minute at the end just to introduce himself. So I do need you to start filling out the evaluation sheets. And here's the part, the questions that I think people don't pay attention to is, and I'd like you to please, what did you find least useful? Like, what could I have done if you don't give me excellence on everything, which I'm not asking you to, although it would make me feel good when I go home and review these tonight. What would it take for me to earn an excellent? What can we do to make your continuing legal education experience favorable to you? Because I know that there's a lot of really good courses and a lot of courses that are not as valuable. And are the courses that we are delivering now, I'm the main speaker at this point. I have other people that speak for me, but as far as going in-house, I have the legal fees presentation. We have one on client relationship mastery. And that's really all the way from the beginning of the case, the advertising. So we go some into marketing, but we heavily on the RPC 7.1, your advertising rules. We then we don't spend much time on, we don't have overlap in the courses, so I don't spend much time on retainer agreements, but then we take you all the way to the end as to what are the obligations under 1.16D. Talk a lot about communication, just how to systematize your office, provide great service. The signature course is Take Charge of Your Life, Personal and Professional. in that's a big goal setting course, because if you look at the RPCs, I just went 2 weeks ago. By the way, Pennsylvania, their continuing legal education board, that's who I'm licensed under. So then in New Jersey and New York, it's reciprocal credits. They gave a presentation 2 weeks ago for providers, just like how, because they really, it's a very transparent organization. They are very easy to talk to. So one of the big issues, and this is a nationwide issue in CLE, is the soft skills. You know, the listening skills, the communication skills. Should there be CLE credit awarded? Now, where I've come down on this is I just put ethics into all my courses. You know, I research the ethics rules, I find the ethical violations. So for example, communication. You know, can you believe 38 cases in 3 years? You know, you'd think lawyers would know how to talk. But here's what was amazing, why I brought up the seminar that I went to for providers, is that we had the chief counsel of the disciplinary board in Pennsylvania who attended and who spoke. And they, even though they didn't have a complete breakdown, it was, why do attorneys get ethics complaints? What are the biggest violations? It's not competence. Okay? Competence is way down the list, maybe 5 or 6. And the point was made, they find out that you're not competent because you didn't return the phone calls. Okay, that's what happens. So competence is not it. It's really diligence. Diligence is the biggest. And diligence, what happens? Well-meaning people, something just gets away from them. And I think a lot of it's because it's just not being organized. And so in Take Charge, we focus a lot on diligence and how to keep yourself right in line. And it's not a case management, because you know you got case management systems out there up the wazoo. It's a personal management system. So just take a couple minutes, if you would, before we wind up, because we do have to go the full 2 hours in order to get the credits. I'd love to let you guys go early. But if you could complete that, and then the one thing that I always ask people to do that come to my CLE courses is walk out of here with some kind of plan of action. Because I'm hoping that you learned something here today, and that there was at least something, one idea sparked of something like, well, I know I should do this, or I'd like to explore this a little bit more, but I know what happens. You take these papers and you go, and there's that stack by your desk, the things you're going to get to later. And whereas, yeah, here you go.
Okay, thank you.
Absolutely, Mike. And whereas if you have just one step of what you can do differently, then that gets you started on making your changes.
Yeah, I mean, the hardest part, I think everyone would agree, is we as lawyers get ahead of things. You know, the client's pushing, you know, get on it, get it done,
Right.
get it filed, get the agreement done, business form, get going.
Right.
So you're focusing on, okay, addressing the legal issues,
Yes.
performing the legal services, so you get ahead of
Your own
the
business.
housekeeping.
Yes, and you know, you are emphasizing one of the very first points that I made, is that attorneys work hard, attorneys are concerned about the client, because when the client comes in, that it's the first thing is that, yeah, you might be thinking, oh gee, I'm gonna make a nice fee off this, but the first thing is, oh my gosh, what do I need to do next to jump into action to help the client? The only advice that I can give you is that take a step back and just remember the last time that you got burned, because you don't want there to be a next time. Make sure the client, because it is so tempting. I know this, clients come in and the client needs a will right now, needs oh my God, going into a nursing home tomorrow. Well, be happy to represent you, but our requirement is retainer agreement signed and a full retainer, or we aren't able to move forward. And that is the only way that you will be assured of not being, basically stiffed on your fees.
Yeah, and sometimes you make the judgment that, you're just going to get it done because it needs to get done, and you're going to take the risk.
Right.
And you're right. There's best practices, and then you make a decision.
Right, and I'm not going to stand here and tell you, Tom, that I didn't sometimes just jump into the work. Did I ever get stiffed on a fee? Once in a while. It didn't happen very often, though, because we were pretty careful about getting the retainer agreements. Because, if the person, just remember, if the person doesn't want to pay you when they're in that severe pain, that severe legal pain, when you've alleviated the pain or protected them in some way, their incentive to fulfill their agreement to you is much less than what it was in the beginning. But on the other hand, again, I know the implication is you want to get it there anyway. Now, again, what did you learn here today that you didn't already know? What's the most useful thing, and what's one thing that you're going to implement tomorrow? What's one thing that you're going to do? And here's another thing to think about in your practice. When you think about what's the one thing I'm going to implement, I don't mean you. I meant your secretary. I meant your staff member. How many times do we sit around with something on our desk that, I'm going to get to it, and then you look at it and say, I don't need to do this, somebody else can do it. So go have your secretary do it. Okay, at this point, are there any other questions? Any other comments that anybody cares to make? Okay, well then I would just ask you to please, and we can, at this point, the session's over. Thank you very much, everybody, for watching this, and you can cut it off.
Thank you.
Thank you.
Thanks.
Thank you.